For decades, the exchange of wealth during marriages in India operated as a highly aggressive financial transaction, completely insulated by the privacy of the family unit. Lawmakers faced a highly specific mechanical problem. They needed to draft a statute that could cleanly sever voluntary customary gifting from calculated extortion without criminalizing normal social traditions. The solution they engineered was the Dowry Prohibition Act of 1961. This statute serves as the foundational legal blueprint for how the Indian state regulates and prosecutes domestic financial extraction. Active across the entirety of India since July 1, 1961, the law attempts to enforce a zero-tolerance perimeter around the marriage contract. By legally categorizing the exchange of assets as a criminal act, the 1961 Act functions as a specialized statutory net designed to trigger the severe prosecutorial mechanisms of broader penal codes. To prosecute a financial crime, the state first has to define exactly what constitutes the illicit asset. That boundary is established in Section 2 of the Act. This diagram illustrates the strict legal definition of dowry. For an exchange to be criminalized, it must meet three conditions. It must be a transfer of property or valuable security, it must be given by a party to the marriage or their parents, and it must be directly related to the marriage itself. The statute carves out two precise exceptions. The first is meher, a mandatory payment from the groom to the bride under Muslim personal law. This is explicitly excluded from the definition of dowry and blocked from prosecution under this act. The second exception protects traditional practices. Voluntary customary gifts like shagun or papri are permitted, but only if they are given without any explicit or implicit demand from the receiving party. Even if these gifts are given voluntarily, Section 2 places a hard financial cap on them. The value of the gifts cannot be excessive relative to the financial status of the person giving them. Section 2 effectively legally isolates tradition from extortion. If a transfer of assets involves an underlying demand or exceeds proportional wealth, it loses its status as a gift and instantly becomes a crime. Once Section 2 defines the illicit asset, Section 3 outlines the strict penalties for executing the transaction. This matrix shows the exact consequences. Taking dowry carries a mandatory minimum 5 years in prison, plus a fine of at least 15,000 rupees. Notice the symmetry. The law penalizes giving dowry equally to taking it, holding both sides to the exact same 5-year sentence. Lawmakers recognize that waiting for money to change hands leaves victims vulnerable. Section 4 penalizes the mere demand for dowry. Here, the matrix expands. The demand alone carries a prison term of 6 months to 2 years, plus a fine of up to 10,000 rupees. Section 4A pushes the boundary even further back, targeting public solicitation. It is entirely illegal to publish matrimonial advertisements that offer a share of property, wealth, or business as an inducement for marriage. Printing or publishing these kinds of transactional advertisements will result in 6 months to 5 years of jail time. To prevent future legal disputes over genuine gifts versus illegal extraction, the Act introduces this document. The list of presents is a mandatory signed ledger detailing all permitted gifts, their exact value, and the giver's name. By criminalizing the advertisement, the direct demand, and the final exchange, these sections construct a zero-tolerance financial perimeter around getting married. The legislation also operates outside of criminal prison sentences, utilizing civil contract law under Section 5 to neutralize the economic incentives of the practice. As this dissolving contract illustrates, Section 5 declares that any agreement made between parties to give or take dowry is entirely void. In legal terms, void means the contract never existed. If a family promises money for a marriage and refuses to pay, the receiving family has no mechanism to enforce that agreement in court. But the law has to account for reality. Section 6 addresses the scenario where dowry is successfully extracted despite the prohibitions. The Act enforces a fiduciary duty. Anyone receiving the dowry must transfer that exact property directly to the bride within 3 months. If the woman dies before the transfer, the property cannot remain with the groom's family. It is instantly routed to her legal heirs. Failing to execute this exact transfer within the 3-month window is prosecuted as a completely separate offense, carrying its own distinct jail time and fines. Through contract invalidation in Section 5 and forced asset transfers in Section 6, the law ensures illicit wealth never legally vests with the perpetrators. Creating strict definitions and penalties means very little without aggressive enforcement mechanisms. Under the Dowry Prohibition Act, the listed offenses are categorized as cognizable. When a crime is cognizable, it grants the police immediate authority. An officer can arrest a suspect on the spot based on a complaint, without waiting for a judge to issue an arrest warrant. These offenses are also classified as non-bailable. This means release from police custody is not an automatic right. A suspect must petition a judge, who has the absolute discretion to deny bail and keep them in jail pending trial. To oversee this, state governments appoint specialized personnel called Dowry Prohibition Officers. Their exclusive job is to ensure the act is enforced, gather evidence, and act on civilian complaints. By making these crimes cognizable and non-bailable, the state bypasses slow judicial procedures, allowing law enforcement to intervene and neutralize immediate threats to victims. The most radical deviation from standard legal norms in the entire 1961 Act is located in Section 8B. In a typical criminal trial, the prosecution bears the burden of proof. The state must prove beyond a reasonable doubt that the accused committed the crime. Section 8B completely reverses this standard. Watch how this scale of justice flips. If a person is charged under this act, the burden shifts entirely to the defendant. The accused must actively prove their own innocence regarding the demand or acceptance of dowry. This inversion solves a specific logistical problem. Extortion occurs behind closed doors, within the private family unit, making standard evidence gathering by prosecutors nearly impossible. This forces a distinct defense strategy. An accused person cannot simply exercise their right to remain silent and wait for the state's case to fail. They must produce affirmative documentation, like the signed list of presents, to justify any transfer of wealth. Section 8B intentionally stacks the procedural deck against the accused, stripping away standard legal protections to counter the inherent secrecy of domestic financial crimes. To fully understand the 1961 Act, we have to view it within the broader ecosystem of the Indian legal system. As we look back at the structural blueprint of the 1961 Act, we see its primary function. While it regulates the specific financial transaction, it acts as the necessary trigger mechanism for the Indian Penal Code, or IPC, when domestic violence occurs. The first connection is IPC Section 498A. This is the penal code specifically targeting cruelty, physical or mental, inflicted upon a woman by a husband or his relatives. When violence occurs, the unmet dowry demands defined by the 1961 Act provide prosecutors with the foundational evidentiary motive required to successfully secure a 498A cruelty conviction. The legal machinery escalates further with IPC Section 304B, which governs the specific charge of dowry death. If a woman dies under unnatural circumstances within 7 years of marriage, and there is evidence that she was subjected to cruelty linked to dowry demands, the charge automatically escalates to a 304B homicide prosecution. The definitions and procedural rules established in 1961 serve as the indispensable primer charge, allowing the Indian state to prosecute the most severe cases of domestic abuse and murder under the Penal Code. The entire framework relies on 3 interlocking pillars: strict definitions that legally separate gifts from extortion, aggressive penal codes that target every stage of the transaction, and procedural inversions that empower immediate arrest. By forcing the accused to prove their own innocence, the law nullifies the natural protection families have when hiding financial crimes behind closed doors. The entire framework is deliberately designed to create a completely hostile, unworkable legal environment for the systemic exploitation of women. The Dowry Prohibition Act of 1961 functions as a highly engineered, interlocking legal weapon constructed to dismantle a complex social crime from the ground up.